This is a very beautiful piece from Miss Spells. I love this lady so much because every time she talks, she's making a whole lot of sense. Now, there's one article she recently wrote that I really find very beautiful. The judiciary will burn Nigeria by Miss Spells. That is just the truth. The judiciary will burn Nigeria. Now, our people have lived with corruption, our people have lived with inefficiency, our people have lived with oppression, our people have lived with bad governance, but our people draw the line at injustice. Historically, the one thing that people world over completely abhor, and that has time and time again demonstrated the capacity to topple kingdoms, empires, or governments, is injustice. Because justice is natural, injustice resonates deeply with everyone on a subconscious level, and when it is wrought with so much impunity on a scale so wide that it affects a large number at once, it has the capacity to unite people of different persuasions, religion, tribal, or otherwise, inflame passions, destabilize the polity, and bring down the status quo. We all saw what happened with Mohbad recently. Nigerians from all walks of life, professionals, underworlds, kingpins, actresses, masses, cultists, thugs, soldiers were united in the call for justice. If the government and the police hadn't responded quickly to start investigation, it could have spiraled and quickly descended into something else. Even then, majority of people are still distrustful as to if justice will eventually be served. The Arab Spring and the uprising in Egypt, Libya and Syria, and the reactionary rise of religious fundamentalism are examples of consequences of the failure of justice systems. The following are relevant. Elections have come and gone, but we will all live with the outcomes and consequences of those elections. In our dear country, Nigeria, electioneering is divided into three. Number one, we have pre-election. Number two, election. And number three, post-election. Post-election phase was designed to correct the ills and errors of the pre-election and election phases and is the most important of the three phases due to its powers of validation and invalidation of prior to phases. Post-election phase comprises ventilation of grievances through legal challenges mounted via petitions filed at Election Petitions Tribunal firmly under the supervision and control of the judiciary. The balkanization, tokenization, and monetization of the important phase is what we are concerned about. In Nigeria, we operate a constitutional democracy, and even though our constitution may not be perfect, it symbolizes the highest authority in our land today and bettered the current order, all arms of government, and is a document we all mandatorily have to obey and follow. It is the social contract that binds all of us Nigerians. It is written in English language and plain enough for ordinary Nigerians to read and understand. The judiciary was created by our constitution and saddled with the responsibility of upholding and interpreting our constitution and all laws made pursuant to it. The election petition tribunals in Nigeria are, to the legal profession in Nigeria, what the Champions League football is to the footballing world. It is indeed the only time when all Nigerians pay attention to the legal sector and judiciary. As a result of the aforementioned and judgment that emanate from the election tribunals have important and serious implications on the confidence the Nigerian citizenry place in their justice system. If the judges who are supposed to uphold our constitution cheat on it for personal gains, they endanger with the small of their cheat the entire order, including themselves, whose existence rests on the sanity sanctity of the same constitution. Very honest. The same judges who think that they want to destroy the Nigerian constitution because of their own personal gain don't know what they have done to themselves and to their future generation. The judgment that have been emanating from the tribunals are a source of worry and threat to the Nigerian justice system because of their lack of fairness, propensity to elevate technicalities and process above substantive justice, misinterpretation, double standard, deviation from standard norms, and open bias. To achieve the impossible, the Nigerian judiciary has mastered the art of striking out, upholding objections to evidence tended to render a petition useless. The PEP judgment has been described by natural legal minds from other jurisdictions as a judgment not based on law, facts, and evidence, pleaded and adduced but endorsed, sprinkled with implicit bias. A rock judgment is one in which the adjudicator would usually frame the wrong issues. The forfeiture argument against APC's candidates at the PEP set squarely within Section 137, subsection 1, specifically as canvassed by the lawyers, but in order to conflate it with Section 137, subsection 1E, which talks about convicted and 10 years, justices of the Court of Appeal framed the issue around Section 137 boldly, instead of framing it around 137, subsection 1D, specifically, blurring the specificity of that issue. Say with APM case on double invalid nomination. Nomination and sponsorship were unilaterally declared pre-election matters by the PEP when the Constitution says otherwise. In Section 285, subsection 14, where the Constitution lists pre-election matters, it uses the words aspirant. The Constitution further mentions candidates in the same section, lending credence to the fact that the framers of the Constitution understand that there is a difference between aspirant and candidate. The Electoral Act 2022 went further to define both words in Section 152. How the word aspirant became a blanket that covers both aspirant and candidates is befolding. If justices of the Court of Appeal cannot differentiate between the words candidate and aspirant, then it becomes obvious they have been promoted beyond their station, and this portends even graver danger for our system. At the Kano Tribunal, we see a clear departure from the wise words of Justice Misura, where she mentioned that the tribunal cannot go into the marketplace to look for evidence for petitioners. Yet in Kano, we see the judges in their full regalia descend into the marketplace for their preferred petitioners and checking even the gutters too for evidence. The fact that the on-stamp ballot tendered by the APC were not listed polling unit by polling unit seemed not to matter anymore since the petitioners were of the APC stock. All of a sudden, the justice remembered the law is that where there are credible documentary evidence, there is little or no need for oral evidence, unlike the position their colleague took at the PEP. Then the judge's uses of uncut words like gang of red cap wearer, bandits in politics, to describe the Kwankwasiya movement which the respondents belong to. They even went as far as likening them to a violent and terrorist cult. They also used phrases like where a party puppet to have his eyes on the judiciary and remove same from his case. You abandoned your case and concentrated on distracting yourself by having your decided eye on judiciary. These words being uttered by judges would make the sane and ordinary Nigerians wonder if bias motor park doubt have not invaded our judiciary already? What is next in the hall of infamy? A Justice Oluomo. Finally, in Enugu Tribunal judgment on PG 103-109, the court was of the view that although Mba attached his NYSC certificate from Form EC9, presented it to the INEC, but because he did not fill the NYSC certificate in the Form EC9, he didn't intend to use it to aid his qualification to be governor. The Constitution is clear on the presentation of false certificates, even if it's a vocational training certificate or share certificate, to INEC being a ground for disqualification. Thanks for supporting the Future News. We're going to read part 2 in the coming days.